Hi, I'm Sam Bone. Welcome to the Bone Law Firm. I wanted to send you this quick video to personally introduce myself and to, walk you through what comes next. I know you probably have a ton of questions right now, and my goal here is to help answer some of them and just demystify this whole process for you. Look, I want to start by just saying, I know this is a really difficult, probably overwhelming time, but I need you to hear this. From this point forward, you are not in this alone. You have our entire firm in your corner, and we are absolutely here to help you. So again, my name is Sam Bone, and the court has appointed me to be your attorney. That means it's my job and my team's job to defend your rights and be your guide through this entire legal system. And I want to be really clear about something right up front. It makes absolutely no difference to us whether a client is court-appointed or if they've hired us privately. None at all. We give every single one of our clients the exact same dedication and commitment. So please know you have our full attention and our full effort. All right, let's talk about the criminal case roadmap. I find that just understanding the journey ahead, it can make everything feel a whole lot more manageable. So the whole thing usually kicks off with an arrest and then a bond hearing. After that, we move into some of the bigger stages, like a preliminary hearing and then something called the grand jury, which might lead to an indictment. So what do all these terms actually mean for you? Let's break it down. Okay, so for felony cases, you'll often have what's called a preliminary hearing. Now, it's really important to note this is not a trial. Nobody is deciding if you're guilty or innocent here. It's just a hearing where a judge looks at the evidence and decides if there's enough, what they call probable cause, to send the case on to the next step, which is the grand jury. So what in the world is a grand jury? Well, it's basically a group of regular citizens. They meet in private and look at the evidence the prosecutor has. If they agree there's probable cause, they issue what's called an indictment. Again, an indictment is not a guilty verdict. Think of it as just the formal, official accusation that officially moves your case into circuit court. After an indictment comes the arraignment. This is a pretty formal court hearing where they officially read the charges out loud. Don't worry, we'll be there to enter a not guilty plea on your behalf. And actually, in a lot of cases, we can file something called a waiver, which is great because it means you probably won't even have to show up for this one. Okay, now for the important part, building our case together. And I say our because this is absolutely a team effort. Your help is going to be crucial. So here's how it's going to work. First thing I do is request all the evidence the prosecutor has. This is called discovery. As soon as I get it, I'm sending a copy straight to you. It's so important that you review it. Then we'll schedule a meeting to sit down, go over all of it, and talk through all your options. That's how we build our strategy, together. So keep an eye on your mailbox. You're going to be getting some letters, and down the road, that big package of discovery materials from our office. And listen, when you get that discovery packet, please read through it carefully. If you have questions, if anything seems off, or you just don't understand something, you need to call me. Seriously, answering your questions isn't bothering me. That's my job. All right. Let's quickly cover what we need from you. Your role in your own defense is absolutely key. Okay, 5 quick things. Number 1, we always need your current address and phone number. This is non-negotiable because it's how you get court notices. Number 2, call us to schedule your appointments to talk about your case. 3, like I said, review every single document we sent you. 4, you have to tell us immediately if you're on probation or community corrections. That's a big deal. And last, but maybe most importantly, do not, and I mean do not, discuss your case with anyone but me. Not your family, not your friends, nobody. And this brings me to a really, really important warning. If you are in jail, you have to understand this. Every single phone call is recorded. The prosecutors, they listen to these calls, and they will use anything you say against you in court. Please be so careful about what you say on those phones. The reason that last point is so critical is because our conversations, yours and mine, are protected. It's called attorney-client privilege. That means they are legally confidential. The only truly private, safe way for us to communicate is when we're talking in person or through letters, what's called legal mail. Okay, so what do you do right now? Let's go over your next steps and how you can stay connected. Here's all of our contact info. You've got our phone number, our address, and our email. You can see our office hours there too. We're open Monday to Thursday from 8 to 5, and we close at noon on Fridays. Please use this information to get in touch. So you might be wondering, okay, how do I actually schedule a meeting? It's really simple. All you have to do is call our office at that number, 256-547 1005 and we'll get you on the schedule. Now, if you're currently in jail, just write me a letter asking for a visit, and I'll make sure to come see you there. I just want to leave you with this last thought. This whole legal process, it's a journey, you know? It's definitely not a sprint. There are going to be times when things happen fast, and other times when it feels like we're just waiting. But through all of it, I want you to know that we are here to guide you, to support you, and to fight for you every single step of the way. We really do look forward to working with you.